discussion is on legal. A plaintiff is a person who is filing a complaint, such as a patient, and a defendant is the healthcare provider that the complaint is being filed on. Our topic is nursing malpractice, and a plaintiff has to have 4 things to file a complaint against a nurse. It's standards of care was not met, duty to act, legal causation, and damages. Lee Neal will now talk about standards of care.
My name is Lee, and I'm going to be speaking to you about the standards of care. Standard of care has to be proven that it was not met, and this relies based on the State Board of Nursing. It is also based on the Nursing Practice Act for whatever hospital you may work in or the state that you work in. It may also be based on your nursing department, such as an ICU, an emergency department, med-surg, and care plans, such as care plans that are set up for a patient based on what kind of needs they need. These are all types of standard of care. Now, failure to meet these standards of care can be such as the following. Failure to assess serious changes in a patient's condition, such as failure to check their neurological status if they're a CVA patient, failure to check vital signs, or failure to check blood glucose levels on a patient who is diabetic in the time that is ordered by the healthcare provider. Failure to take appropriate action or notify a physician when there are significant changes in a patient's condition or when something is outside of a range of norms. This could be if a patient continues to complain of a headache and you don't notify the physician that they're having a severe headache. The patient is having shortness of breath that continues on, and after what nursing interventions you can do, if you don't notify that physician and the patient continues to get worse, this is failure for you to do standard of care. Also, this would be if the patient was having shortness of breath and so forth, if you failed to sit them upright, apply supplemental oxygen, anything that you can do that is within a within a nurse's standard of care or standard of scope would be considered failure to meet that standard of care. Medication errors and documentation errors. Medication errors such as not giving the correct medication, not giving it on time, or omitting the medication. Nurses cannot omit medication. This is done all the time in the hospital. If a blood pressure medicine is not supposed to be given due to a blood pressure, a physician is by law supposed to be notified and told that the medicine has been withheld. If you do not notify the physician when you withheld this medication, you are by law prescribing and omitting medication. Documentation. If you did not document it, it did not happen. Anything that is done with the patient, anything that happens with the patient has to absolutely have been documented. And I kind of have a scenario for you that kind of makes sense of this. The patient is scheduled for BP medication. However, the patient refuses to take this medication due to the belief that this medication does not work or they do not like the side effects. Despite the nurse's education in regards to the refusing of the medication and what may happen if the patient doesn't take it, the patient still refuses. Later that day, the patient suffers from a CVA secondary to hypertension. The nurse is held responsible for not administering the BP medication. Despite the nurse not being at fault, this nurse did not document the reasons for why she withheld the medication, and she did not contact the primary care physician. Therefore, there is no proof that the patient refused the medication and that all legalities were explained to the patient and all adverse side effects were explained to the patient, so therefore the nurse is held by law accountable for it because she has no proof that she didn't do it. Another thing that's considered standard of care of not meeting it is misusing medical devices or implants, such as using pillows, side rails, or other devices as restraints to restrain a patient without consulting a physician or a healthcare provider first. Failing to get informed consent from a patient, this is also considered failure to meet standard of care. If you do not have consent and understanding from a patient before you perform a procedure, and it may be undesirable to that patient, this can be considered battery. Battery is when you actually do something to a patient that is not what they want, such as actually physically touching them, performing a surgery, so forth. They can get you for battery. Assault would be if you threaten to hit that patient, threaten to restrain that patient. Assault is verbal. Battery is the actual physical act in doing it. Failure to perform a procedure correctly and not meeting your standard of care, which you have learned in nursing. This is such as improper technique with IV cannulation, non-sterile technique with Foley insertion, not keeping a sterile field, Anything that you learn in your scope of practice as nursing, when you receive that nursing license, it tells the general public and hospitals that you as an RN should be adequately trained and should have the education to perform these procedures. In order to prove malpractice, the plaintiff has to prove that the care that they received from you was not to par with what they would receive from any other graduate or any other nurse in a nursing facility. Now, this can vary based on standard of care. Like I was telling you before, standard of care varies differentiated on what level of a unit you work in. So by saying this, I mean if you as a RN in an ICU fail to do something to an intensive care standard of care, your standard of care is considered completely different than a registered nurse who just graduated from an RN program, because you have been placed in that ICU, you have learned those special procedures and so forth. If the plaintiff can't prove that you didn't meet standard of care, then they technically don't have a lawsuit. And if you can demonstrate that you successfully met the standard of care, then there really is no malpractice. Next, we're going to talk about duty to act, and that's going to be gone over by Megan.
Today I'm going to be talking to you about when the duty to act is present. Once a nurse accepts a report and assigned their patients, the nurse has agreed to care for those patients. By accepting the assigned patients, the nurse has assumed a duty to treat the patients with competent and careful needs. Res ipsa liquitor is the Latin term that means the thing itself speaks. One of these four things has to be proven in court for your case. The situation ordinarily would not occur without someone's negligence, such as checking blood sugars. The situation in this instant probably did not occur without someone's negligence, such as using a sterile technique and them getting a UTI. And the situation, it was caused by instrumentality that was under the exclusive control of the defendant, such as putting the side rails up to prevent injury for a dementia patient, or it was not caused by in any way by the plaintiff. Next, Tasha is going to be talking to you about legal causation. I will be talking to you about legal causation. The plaintiff must establish that had standards of care been followed, the injury or damages to the patient would have been avoided. A legal cause of action for negligence usually exists when it is determined that the breach of the standard of care approximately caused by damages, usually physically or emotionally in nature, to the victim. I'm going to be talking to you about the damages the patient must suffer in order to file a malpractice suit. First, there's physical. The plaintiff suffers physical damages that was secondary to malpractice or negligence on a healthcare provider's part. An example of this would be an amputation of an extremity secondary to an infection. Second is emotional. The plaintiff suffers emotional damage that was caused by a situation that resulted from negligence on the healthcare provider's part. An example of this would be post-traumatic stress disorder from an operation without proper anesthesia, such as recurrent nightmares, fear of undergoing surgical procedures. Next is monetary, where the plaintiff suffers monetary damages from fixing damages caused by the healthcare provider. Examples of this are reconstructive surgery, counseling that the patient must undergo, or medications and subsequent doctor visits. And the last damage is property, where the plaintiff suffers damages to personal belongings secondary to an action carried out by the healthcare provider. The plaintiff wrecks his or her vehicle moments after being told they are medically sound to drive, which in result causes property damage to his property or the property of others. In conclusion, we went over the four key elements that a plaintiff must prove to proceed in charging a nurse with malpractice. Standards of care were not met, duties to act were not followed, legal legal causation and damages were caused. Thank you for watching our